So welcome. It is such a joy to be here with you. Welcome to this, the opening plenary of the 116th ASIL annual meeting. We're very excited to welcome you this evening to Washington, D.C. for another first for the Society. This is the first annual meeting that is hybrid, so part virtual, part in person. We have hundreds with us here in Washington, D.C., and hundreds more who are joining virtually and live streaming the program as we go. So welcome to everyone in your homes. Welcome to all of you who are here with us. We're so happy to be together after too long apart. So we begin this annual meeting, as is our tradition, with the Grotius Lecture. This lecture, as we all know, was named after a luminary considered to be the father of transnational law, and this year celebrates its 24th anniversary. It's become a mainstay in our community for gripping treatments of important issues of international law and policy. The Grotius Lecture has covered topics as varied as a third world view on the promise of international law, harmony and dissonance in international law, just war and humanitarian intervention, and balancing the rights and responsibilities of multinational corporations, to name just a few. We look forward to continuing that tradition today. I want to welcome our distinguished guests, Judge Charlesworth, Professor Karima Bennoune, and Dean Fairfax. ASIL is really proud of its long partnership with the American University Washington College of Law for 24 years, and hopefully 24 more to come, and the important contribution of this series to the field. Dean Roger Fairfax, who I've had the great pleasure of meeting today, is Dean of the American University Washington College of Law, is a prominent legal scholar, educator, and nationally known expert on criminal justice. Prior to his career in academia, he practiced law with O'Melveny and Myers and served as a federal prosecutor through the Attorney General's Honors Program in the Public Integrity section of the Criminal Division of the U.S. Department of Justice. He's an elected member of the American Law Institute, and in 2019, Chief Justice John Roberts appointed Dean Fairfax to the Judicial Conference of the United States Advisory Committee on Criminal Rules. I'm so pleased to welcome the Dean to the podium today to get us started.
Thank you so much, President Amirfar, for that wonderful introduction. Good evening. We could do better than that. This is ASIL. Good evening. All right. So, on behalf of the American University Washington College of Law and our International and Comparative Legal Studies program, we welcome you to the 24th Annual Grotius Lecture, the first one since the onset of the global pandemic. And I know it is so wonderful for us to be back together. And this evening's event also has particular significance for me, as this is the first Grotius Lecture since I became Dean of the American University Washington College of Law last summer. And I see one of my predecessors, Claudio Grossman, here in the audience as well. And we are so proud of our sponsorship of this lecture. And I want to begin my greeting with a sentiment that is animating my tenure as Dean, and that is gratitude. I want to thank everyone responsible for organizing this fantastic evening, including the American Society of International Law, President Catherine Amirfar, and I understand the gavel will be handed over very soon as tomorrow, but I've heard wonderful things about your tenure as president, so thank you for everything that you've done. Executive Director Mark Agras, who I see here as well, and all of the wonderful ASIL staff. I also want to thank my colleague, Professor Patty Day-Alai, who I know is somewhere nearby, and all of my wonderful colleagues at WCL for coordinating this event. Now, at WCL, we have a commitment to the promotion and protection and development of international law and to a global outlook that remains as strong as ever. And 24 years ago, the International Legal Studies program at WCL and ASIL, in partnership, launched the Grotius Lecture as the opening event for ASIL's annual meeting. And our intention then and still today is to use the Grotius Lecture as a public forum to address important issues facing the world and to hear diverse voices and approaches to international law. So this year, we're proud at the Washington College of Law at American University that we are celebrating the 40th anniversary of our international law program and our LLM in international legal studies. And we invite you all to the party that's going to take place this fall as we celebrate that milestone. And again, we're so proud of that program and its legacy. Because our faculty, through their scholarship and through their activism, continue to contribute to building a peaceful world through the international rule of law. And we remain committed to playing an active part in our search for a just world that respects our common humanity and seeks to preserve it. In that same vein, the prominent and distinguished Grotius lecturers and discussants over the past 24 years have reminded us all of the importance of addressing our challenges on a global scale, appreciating and respecting our differences, but also our common humanity. That's why I'm so pleased to introduce this year's lecturer and discussant. Our Grotius lecturer this year is Judge Hilary Charlesworth. Now, Judge Charlesworth was recently elected to serve on the International Court of Justice to complete the term of the late Australian Judge James Crawford. And I am told that she is only the 5th woman to serve on the ICJ in the 75 years since its founding. Judge Charlesworth is an Australian barrister and solicitor, law professor, and renowned scholar of international law. And she taught law for more than 30 years at the University of Adelaide, the Australian National University, and the University of Melbourne, and as a visiting professor at numerous universities all around the world. Before her election to the court, she previously served as an ad hoc judge on 2 matters that came before the court: a dispute between Japan and Australia regarding whaling in the Antarctic, and another between Guyana and Venezuela involving an arbitral award. Now, unfortunately, as many of you know, Judge Charlesworth could not join us in person this evening. However, she has graciously recorded her lecture, The Art of International Law. And our distinguished discussant today is Professor Karima Bennoune. Professor Bennoune holds the Homer Angelo and Ann Berryhill Endowed Chair in International Law and is the Martin Luther King Jr. Professor of Law at the UC Davis School of Law. And she's currently a visiting professor at the University of Michigan Law School. She specializes in public international law, international human rights law, and also issues related to culture, extremism, and terrorism, and women's human rights. Professor Bennoune served as a UN Special Rapporteur in the field of cultural rights between 2015 and 2021, and she was appointed as an expert for the International Criminal Court in 2017 during the reparations phase of a groundbreaking case concerning the intentional destruction of cultural heritage sites. Since 2018, she's been a member of the board of editors of the American Journal of International Law. She's a former legal advisor for Amnesty International and has carried out human rights missions around the world. And in 2014, she was the winner of the Dayton Literary Peace Prize for nonfiction. Professor Bennoune will offer remarks after we hear Judge Charlesworth's recorded lecture, which will begin momentarily. Again, thank you all for being here this evening, and please enjoy the lecture and the comments. Thank you so much.
Good evening. I'm really sorry not to be able to be with you all in person in Washington, but the court is in the middle of hearings here in The Hague. I'd like to thank both the Society and the American University Washington College of Law for inviting me to deliver the Grotius Lecture this year. It's a great honor, and it's also a delight to be back at the annual meeting, at least virtually. I also want to thank my friend and colleague, Karima Bennoune, who generously agreed to offer some comments on the lecture after I've spoken. I've also assigned her the task of handling any tricky questions at the end. She'll be able to answer them all. International lawyers study international law primarily through its written texts, treaties, official documents, judgments, and scholarly works. By contrast, in this lecture, I'll consider how the visual interacts with international law, both formally and informally. I see this as one aspect of the theme of this annual meeting, personalising international law. The visual is significant in framing how individuals inside and outside the legal world experience international law in their daily lives. My argument is that the visual dimension does a lot of work in international law and can both shape and transform conceptions of the discipline. The visual and the aesthetic are integral to the authority of international law. They deserve, in my view, much greater attention and analysis. The historian Annie Gulick has described international law, and I'm quoting from her, as both an institutional reality and an imaginative project. My claim is that the visual shapes both aspects, institutional and imaginative. In other words, law has a material context, but it's also a way of seeing the world. International legal scholars who've written about art and aesthetics have tended to focus on what art can do for international law. For example, human rights scholars have turned to art as a way of exposing the nature of human rights abuses. We can see this, for example, in a study in 2017 by the European Union Agency for Fundamental Rights. It's a study on the arts and human rights, which called on artists to reinforce, and I quote, the human rights message. The report argued that, and I'm quoting again, perceptions are more powerful than facts, and art is all about perception. Art, it went on, can thus transcend barriers such as politics and language. End quote. By contrast, in this lecture, I'm using the idea of the art of international law not to make a normative argument, but more in a descriptive way, as a means of investigating how the visual informs and shapes international law. Of course, just as the texts of international law can promote varying concepts of justice, the visual dimension of international law can also have progressive or regressive effects. In this lecture, I want to acknowledge I'm drawing on a rich theme of scholarship on visuality and more generally, and more recent work on visuality and international politics and law, and you'll be able to see all my depths in the footnotes when this lecture is published. So my plan for this lecture is first of all to offer an overview of what attending to visuality might reveal about international law, and then discuss two quite different examples of visuality in law. So to take a bird's eye view, there are many different ways in which the visual interacts with international law. And I'm going to mention 6 of these, but of course, many of the categories I'll mention do overlap. So first of all, the visual can symbolize or bolster the law's authority. An example is a image of a judgment of the International Court of Justice. This is one of the judgment actually in the whaling case that's signed with its splendid red wax seal. And you can also see on it perhaps some of the original initialing of the judges. And this splendid red wax seal, this visual element, and the signatures manifest the authority of the document. Portraiture provides another example of visual emphasis on legal authority. So here we have a portrait of the namesake of this lecture, Grotius, in the Capitol building, a relatively modern one, but displaying him very much in his persona as the father of international law. And we can also see this as another aspect of the personalization of international law. Secondly, images can also illuminate the law or its limits. And a painting that's much beloved of international lawyers, an image, is Picasso's painting of Guernica, which of course was a response to the fascist firebombing of the Basque town of Guernica in 1937. We can see that international lawyers are quite attached to this image. It appears often on the covers of textbooks. So Guernica is taken, I'm gathering by the popularity of this image, to be saying something about international law, presumably that we need more of it. A third way that the visual relates to international law is the way that art and law can reflect each other. There's been some really interesting work done on the impact of architecture on international law and vice versa. So scholars have studied the architecture of international organizations, for example, how architectural style is connected to patterns of legal and political change, and vice versa. So Miriam Back-McKenna has argued that the architecture of the International Labour Organization and the Palais des Nations, represented here in Geneva, their building reflects tensions between the Westphalian era of state sovereignty and the move to internationalism. She also makes the argument that the UN building in New York, very much in the international style, endorses European modernism as a universal language. And you'll probably recognize the UN Secretary General, Dag Hammarskjöld, here in front of the General Assembly building in 1943. A fourth way that these two categories overlap and interact is that images can galvanize or justify recourse to the law. So this is very much at the heart, that idea of the art and human rights movement. And here you have the Chinese artist Ai Weiwei with the giant inflatable refugee boat filled with hundreds of figures. And you can see that the artist himself has invoked the law in the title of this work, The Law of the Journey. A fifth way that the art and international law interact is as a method of propaganda to promote particular views of international law. So, for example, Kate Miles has analysed various paintings of colonial treaty making, for example, this one by Agostino Brunias, in an article that Kate wrote. And this painting is depicting a 1773 treaty entered into between the British and the indigenous inhabitants of St. Vincent in the Caribbean. And Kate Miles suggests that the visual discourse of international law was represented by this painting, was an important element in shoring up empires and reinforcing the image of international law as the civilizing force that was universally applicable. And the final way that I'm going to, that I think is interesting, I haven't exhausted all the ways that international law and art interact, but this is an example from my own country, Australia, where a visual object can actually constitute the law. So this is a painting of the Niuru law from Arnhem Land, presented by Yolngu elders to the Northern Territory government and to the Chief Justice of the Northern Territory in 2011. So the law contained in this painting covers many areas. Indeed, it actually has the status of what we might understand as a constitution, providing for peace, order, and good government for the Yolngu people. So the image itself contains both religious and legal power. So having given that overview, I'd like now to turn to my first example of the relationship between the visual and the authority of international law, the design of the Peace Palace in The Hague, where I currently am delivering this lecture. So there have been some very interesting work, and a number of scholars have discussed the history and symbolism of this building in illuminating ways. And I'm going to focus on the competition to build the Peace Palace to emphasize the variety of models of international justice were on offer when this design was selected. So the idea of having a permanent seat for international justice emerged from the Hague Conference on Disarmament in 1899. And here's a photograph of the delegates to that conference. Over the 10 weeks of the conference, work towards a disarmament convention quickly went onto some rocky shoals. A proposal made by the British delegation for an international arbitral court emerged during the conference as a way of saving face and salvaging the hopes of the peace movement. The Russian jurist, Frederick Martens, came up with the idea for a physical structure to house the permanent court of arbitration, as well as for future peace conferences. And Andrew Carnegie, the Scots-American steel magnate, was persuaded to fund the building, and he announced a gift of $1.5 million in April 1903 for a courthouse and a library of international law. So the second Hague Conference was held in 1907, between June and October that year, and a ceremony for the laying of the foundation stone, you can see here, was held on the 30th of July. So the Carnegie Foundation, that still runs the Peace Palace building, supervised the location, finances and construction of the building. And the foundation sponsored an international competition for design in 1905 through the following year, attracting 216 entries. They were all numbered to make them anonymous for the international jury. The jury came to a decision within 6 days, raising the concern that the judgment had been rather superficial. And the design was by the French architect Louis-Marie Cordonnier, who was from Lille. And you can see this was his design. It had a very high-pitched roof made of red brick. And this was rather in a regional style rather than international style, certainly reminiscent of the medieval guild halls in the Netherlands and Flanders. The Prize Committee, in their rubric justifying the choice, noted that the design, and I quote from it, was inspired by the architectural traditions of the Netherlands in the 16th century. This is sometimes called Flemish Gothic or Dutch Renaissance, and it is a style that's associated with the era of Hugo Grotius. Andrew Carnegie, the funder, was deeply disappointed in the chosen design of the building because he had imagined it as a neoclassical building in the style of the Parthenon. He wrote that the Peace Palace, in his imagination, I'm quoting from him, was to be the most holy building in the world because it has the holiest end in view. Even the Dutch Parliament weighed in on the design. They were very concerned about the choice of Cordonnier's design. It was thought to be quite backward-looking, too Dutch, too parochial. Was it too overwrought and too fussy with its many towers, as you see here, its gables and roofs? And the New York Times architectural correspondent in 1913 said of it very dismissively that it was, and here are the words, wholly imitative of the architecture of another era without the slightest effort at large symbolism of modern life. The writer said it was old and retardative in style rather than what it should have been, according to that writer, new and progressive. Cordonnier was also dismissed as a second-tier architect, competent but without imagination. And it was considered widely that he was quite a surprising choice, given that much higher profile architects, such as the Austrian Otto Wagner, whose design we'll see in a minute, had entered the competition. This was, in fact, Otto Wagner's offering in the competition. He was a master of the Vienna secessionist style, which embraced geometry and abstraction. And he actually had called his design the art of the age, but he only got to 4th prize. Many of the entries hark back to historical styles. There were some, for example, the Pantheon or Gothic halls of Anglo-Saxon colleges. You can see here, this is the 5th place winner in very much in the neoclassical style. This was design of the American architects Greenlee and Oldham. And there were also some quite remarkable ones. One that always struck me as quite remarkable, this by Giuseppe Manchini of Italy, which looks like a mausoleum. And there's also perhaps an even more adventurous one by Félix Desbarres, an architect from France, that features, you can see, a pyramid on top. There was really only one resolutely modern design, and this was by the Finnish architect Elil Sariman, and he called this design Long, the man. You can see that the design is quite sculptural with simple forms and very little clutter. And it's striking that the architectural press at the time showered it with praise, but it certainly didn't impress the competition jury, and it failed to be among the 44 shortlisted works. A contemporary Dutch architect at the time, KBC de Basel, said admiringly of Sariman's design, and these are his words, "The building, despite its solemnity and solidity, has a sense of life and movement, and this serious energy is underlined by the delicacy of the decoration." De Basel said of the design that it was throbbing with life. Well, at one stage, the Carnegie Foundation itself considered overriding the decision of the jury and Cordonier's design, in fact, to select Sariman's design. But this plan was ultimately abandoned because of a critical report on the technical and fiscal aspects of the Sariman design. And I think I wonder if this confident simplicity of the finished design has some parallels with the bold approach taken to international law, taken by contemporary Finnish international lawyers such as Martti Koskaniemi, Outi Korhonen, and Ini Talgren. You can see this, I apologize, it is not terribly clear, but it's a cartoon about the building in the Dutch press. This was a satirical comment on the competition. And you can see that the cartoonist has given the winning design a cacophony of styles with a pair of guns. You can see at the front entrance, and you might be able to see the golden cup idols all over the grounds, really emphasizing the idea of the vainglorious pomp that was in the mind of the jury. Well, in the end, as you possibly recognize, Cordonier's design was in fact scaled back considerably, but only because it would have broken the foundation's budget. So, for example, its 4 large towers ultimately became 1. And here are some images of the building process going on. So the Peace Palace was finally opened on the 28th of August 1913 in a ceremony. You might be able to see Andrew Carnegie in the centre of the photo there. But the question I want to ask is, well, what visual identity is projected by the choice of building? What ideal of international justice is built into its bones? Certainly, we can see it's resolutely Western in style, and also that it harks back to an imagined past. Marco Duranti has pointed out that the building didn't reflect, for example, any of the mass internationalist movements, for example, Marx's idea of some sort of proletarian solidarity across national borders. And according to borrow Marco Duranti's words, it displayed an older cosmopolitanism suited to European elites who saw themselves as impartial custodians of peace, unmoved by mass politics. So on this analysis, the function of the Peace Palace really was to distinguish the cultural boundaries in international law. And Duranti has commented that it illustrates the common standards required for attainment of the sovereign rights and full membership in the Society of Civilized Nations. So we can see in the building little sign of colonized peoples who were regarded, again borrowing Duranti's words, as passive recipients of humanitarian assistance rather than active participants in the international order. So in terms of the annual meeting's theme, personalising international law, we can see that the Peace Palace celebrated the traditions of particular groups of persons while excluding others. In this sense, the Peace Palace, you can see here some of its interior design. It's really, we can read it as a material version of what Tony Angie has called the dynamic difference. He defines that as the imagined gap between the civilized European world and the uncivilized non-European world, which could be bridged only through adherence to particular forms of politics and law. I want to move now to my other example of the interaction of the visual and international law by turning to photography in the International Court of Justice. So I'm turning from the visuality of exterior images of international adjudication, such as we did here, to the use of images in international. litigation. Legal institutions work with photographs because they're taken to provide objective information. Cameras are assumed to be, in Leslie Moran's words, benign machines that merely record. And Susan Sontag, the famous theorist of photography, has observed that photography allows us, and I'm quoting her here, to appropriate the thing photographed. Photographed images do not seem to be statements about the world so much as pieces of it, miniatures of reality that anyone can make or acquire. Well, there's certainly been some very interesting scholarly discussion of photography in domestic court cases and also in the context of international criminal tribunals. But there's been little attention to the role of images in the International Court of Justice, and yet they are used all the time. So, as I've said, I want to consider the use of photography in the Niuru case that came before the International Court just some decades ago. So this situates the very small Pacific island of Niuru. You can see a neighbour of Australia, and also you can see a sense, I don't know from the scale in the close-up map, that it's extremely small in territory. So rich phosphate resources were discovered on Niuru at the start of the 20th century. Niuru had been a German protectorate until the First World War. After the First World War, Australia, New Zealand and the United Kingdom became mandatory powers under the League of Nations and later trustees under the United Nations. So those three states created a corporate structure to exploit Nauru's phosphate, which was extremely valuable as farming fertilizer. But the mining caused massive environmental destruction. Niuru ultimately became independent in 1968, and this is a photograph during the independence ceremony where you can see representatives of the three trustee nations and together with the first president of Niuru, Hamoda Roberts, so taken in 1968. In 20 years later, in 1989, Niuru instituted proceedings against Australia relating to a dispute over the rehabilitation of phosphate lands mined before Nauru's independence, as well as a dispute over the historical calculation of royalty payments. Now, Nauru's argument, and there were technical reasons why it didn't bring the action against the United Kingdom and New Zealand also. Niuru claimed that Australia had breached its obligations of trusteeship under Article 76 of the UN Charter and the trusteeship agreement of 1947. The Niuru also identified breaches of Australia's obligations under general international law, notably the principle of self-determination and the principle of permanent sovereignty over natural wealth and resources. Australia challenged both the admissibility of Nauru's application and the court's jurisdiction, filing its preliminary objections in December 1990. And the oral arguments on this preliminary phase took place over 8 days the following year in November 1991. Now, Niuru was very thoughtful about its imagery, and it commissioned a very well-known Melbourne photographer who's still alive, John Gollings, and here he is depicted here, to take photographs in preparation for the court case. And I think he took this photograph himself. Many, as you'll see, many of these images were aerial shots, and he recalls that they were taken through the open window of the pilot's seat at 20,000 feet in the air, and you can see that the photographer had to be on oxygen while he was taking them. So some of Gollings' photos were included in Nauru's memorial only in black and white to show Nauru's unique topography. This is one of them, and then to illustrate the devastation of the land by phosphate mining and the fact that much of Nauru had been effectively mined out. And it was said in the written memorial of Niuru that by the time Niuru was returned to the Nauruans, and I quote from the memorial, it was neither cultivable nor habitable, and for all practical purposes, the land was useless. I was very struck in the Niuru Memorial to see there were a number of images of photographs of pockets of forest, particularly in this image was in black and white in the memorial, but I've shown it to you for contrast. This is some forest that still surrounds the Buada Lagoon, which is in the middle of the island. And these were included to give some indication of the appearance of the main central plateau in Niuru before its mining. So these images, especially of this halcyon pre-mining time that was indicated by this image, provided powerful support for the claims in the memorial, and I'm quoting from the memorial, that before the island was mined, Nauruan landowners were able to identify their own areas of land through stone boundary markers. The memorial went on, various trees were grown on this land, such as pandanus and coconut, which were much valued. But once mined, the areas became completely inaccessible and, without careful survey, almost unidentifiable. Now, the Nauruan memorial conceded that there was a substantial natural regenerative process that occurred on mined land, with ferns and other plants taking root in the pit bottoms. But he made the point too and illustrated by the photographs. And here's a quote from the memorial: owing to the pinnacle proliferation, such land is inaccessible and completely unusable. Going through the records, I was unable to find any photographs that Australia used in its arguments. But interestingly, it annexed to its statement of preliminary objections an article from the National Geographic. So it effectively allowed the National Geographic to provide its images. And you can see the title of this article that was part of the Australian case, entitled "This is the World's Richest Nation, All of It." And this appeared in the National Geographic magazine in 1976. So quite some time before the case was actually brought. So you can see in a fairly classic National Geographic style, the article included these large and colourful photos. And the photos that it reproduced really emphasised Nauru's carefree lifestyle. This is an example of that. And its affluence. Here's the president with an imported expensive car. And the article in the National Geographic, submitted to the International Court of Justice, quoted an Australian official saying enviously, "We die worrying, they die laughing." So this idea of the cheerful islanders. It's striking that counsel for Niuru, Professor V.S. Mani, really emphasised Golling's photos during the ICJ hearing. We know that from the written record. Professor Mani quoted a number of images, and some of them were verbal images, in a 1962 report from a United Nations visiting mission. And he quoted them as saying, "It's impossible to imagine in advance the extraordinary picture which the lands present. Acres of barren, sharp, coral pinnacles, like huge, jagged, crowded gravestones." Professor Mani then drew the court's attention to this photograph, an aerial view of the mined-out land. And he was trying to emphasise the point that phosphate mining on Niuru was unlike other forms of mining, precisely because it leaves the limestone pillars, which are known as coral pinnacles, in its wake. So during the argument, Professor Mani for Niuru presented the photographs in themselves as conclusive proof of environmental degradation. He said to the court that the court would immediately appreciate the problem from the photos. And he said, well, he then didn't need to engage in a lengthy legal discussion of elevated environmental standards. Professor Barry O'Connell, another of Nauru's counsel, in turn took the court to this photograph in black and white to emphasise the unique nature of Nauru's situation. And he said during the hearings, at the conclusion of the phosphate mining, the usable territorial area of the country will be reduced by 80%. Well, Australia's counsel were quite stung by all these visual images. and Gavin Griffith, who was then Australia's Solicitor General, presenting Australia's case, tried to counter Nauru's use of photographs, pointing out, and I'm quoting from his speech here, to put this devastating view into perspective, he said, "We must remind the court that some 2/3 of mine lands have been excavated by Nauru since independence." Thus, he said, 2/3 of photographs such as these fairly depict exploitation for which Nauru accepts responsibility. So he was trying to emphasise this wasn't all Australia. Professor Mahoney for Nauru responded rather tartly to this claim, saying that Nauru was well aware of its responsibility for 2/3 of the rehabilitation, and that it had been clear about the fact that the photograph wasn't in fact from an area of Australian-administered mining operations. My predecessor here at the court, James Crawford, for Nauru, this was the first case in which he argued before the International Court of Justice, arguing for Nauru. He pointed to the photograph to answer an Australian argument that on Nauru's independence, Australia's obligation to rehabilitate the mined lands was devoid of object and thus extinguished. And I'm quoting James here. He said, "One only has to look at the photograph to see that the obligation was not and is not devoid of object. It is true," he said, "that after independence, Australia had no right simply to come onto the land and carry out its own rehabilitation schemes, contrary to the wishes of the law. But that did not mean it was free of any obligation of the law." It's striking that the photos in Nauru's memorial contain no human figures. There were many aerial shots emphasising Nauru's small size and vulnerability. So we can see images of the Pacific paradise contrasted with the moon-like effects of the phosphate under it. So we can see that Nauru's legal arguments were intertwined with imagery. This gave great weight to the more arcane legal arguments. Well, ultimately, in 1992, the International Court rejected most of Australia's preliminary objections. And James Crawford later, reflecting on this case, he later noted that the court's judgment, I'm quoting him here, had exposed a certain sympathy towards Nauru's argument on the merits. So the International Court's narrow reading of the monetary gold principle allowed it to override Australia's objection that the court couldn't determine Australia's liability to Nauru without having its co-administrators, the United Kingdom and New Zealand, equally before the court. And finally, of course, the case never came to the merits because before the merits phase was reached, Nauru and Australia agreed to discontinue the case, reaching a settlement in September 1993. Now, the court's judgment on jurisdiction makes no reference to the photographs, and yet it's pretty clear that the photographs had considerable ethical power. They certainly sent a clear message about the type of self-determination that Australia had granted Nauru. I'm quoting here from Tony Yangi, who has written very powerfully on Nauru, and he said, and here are his words, so Australia had effectively handed over Nauru, a devastated landscape, to a people that were deliberately neglected and subordinated. Mining, Andy says, was the only industry that Australia fostered on the island, so Nauru's only means of economic development was the continuation of the mining that was so damaging to the island. End of quote. It's fascinating going back to the Australian archives on the case, which shows that some Australian officials and politicians felt rather stung, personally stung, by the Nauruan action. They noted the perceived profligacy of the Nauruans, and they also were keen to point out Nauru's own failure of responsibility for rehabilitation. But others recognised Australia's continuing responsibilities towards Nauru. If the matter had reached the merits, Australia planned to argue that it had already paid generously for Nauru phosphate, and that, and I quote from an Australian argument, the Nauruans have been more than adequately recompensed, and that with prudent financial management since independence, they could have provided for the future. But such positions, which never got actually aired in the court, of course, were certainly very much undermined by the photos. It's interesting how powerful the photographs were to Nauru's case generally, because before the court hearing, but just after its memorial had been filed, Niuru hosted an exhibition of John Golling's photos at Nauru House in Melbourne in June 1990 during World Environment Week. And it hired a media consultant, and it called the exhibition Nauru 1990, The Stark Reality. And one can't help thinking they very much had an international audience in mind. So the exhibition had a glossy brochure, Nauru 1990, this was the type of brochure, an environmental challenge for Australia and the Pacific. And the brochure claimed that the photographs captured the results of ever-creeping devastation on a formerly lush tropic island, as well as, the brochure went on, the extraordinary and all-pervasive intrusion of the phosphate industry into the lives of inhabitants. So here are some of the photographs from that exhibition. And this is one that was shown, for example, showing the, in the words of the brochure, the desolation and consuming heat of the mine plateau, because you can see in this photograph what's called the oven effect, the plateau being so hot that the updraft above it disperses clouds. Another photograph that was shown in the exhibition, and this wasn't included in the original, is this rather poignant photograph of an Australian rules football match, which, again, in the words of the brochure, demonstrates the intrusion of the industry as the game is played jammed up against the immense and all-embracing phosphate dryers. Well, this Nauruan media campaign was extremely successful and was also monitored by Australia's Department of Foreign Affairs and Trade. The Nauruan exhibition was covered by national press and television, and it was pitched very much as a David against Goliath fight. And here are some of the images that figured in it. In a widely broadcast television interview, the photographer John Gollings claimed these images prove the court case. Well, of course, that's not accurate from a legal perspective, but there's no question that the image's emotional and ethical impact was powerful, which of course explains why Australia was so keen to challenge their accuracy during the oral argument. And of course, Australia was unable to marshal any images to counter the Nauruan ones or to give effective power to its side. Indeed, Australia, we can see from the files in the Australian archives, seemed very conscious that it was being depicted visually in a most unappealing role as an imperial power in this context. So we can then understand Nauru's deployment of images in the World Court litigation as the visual effectively transmitting the voice of a marginalised actor in the international order. Photographs don't just record facts. They're not miniatures of reality, Susan Sontag's words. Rather, they're images whose meaning and significance are shaped by social and cultural factors and are mediated by each observer. So international lawyers need to consider the aesthetic impact of images and pay attention to their framing. As Ronald Barthes has reminded us, images can have multiple levels of meaning, not only informational and symbolic, but also a non-articulated meaning that lies beyond language and operates primarily on the emotions. So to conclude, images not only shape but indeed constitute the world around us. As we can see in current conflicts, they can be used by all sides to create an asserted reality. It's unsurprising then that the visuality of law can be as significant as its textuality. The written word provides just one dimension of law's power. Just as international law influences some aspects of art, art can reflect, influence, or even shape events in international law, sustain or undermine the law's legitimacy and authority. Paying attention to the visual highlights two dimensions of international law which gain power precisely through being invisible. The first is the role of framing and representation of international law. The art and architecture of the Peace Palace, for example, and there is an example here, reinforces particular ways of seeing international adjudication and its practitioners. Attention to visuality sheds light on the way that the international community is represented and the question of who belongs and how. At the same time, visuality can be a powerful tool for those at the margins of international law to challenge its limits. A second feature of this interaction is that attention to visuality underlines the creative, symbolic, and affective dimensions of the world of international law, as the use of photography in the Niuru case indicates. We accept that there's creativity, subjectivity, and interpretation wrapped up in every artistic work. We observe the technical skills of the artist, their insights and imaginations, and look for the signs of the artist's persona and their subjectivity. Indeed, often the greater the creativity and subjectivity, the more we appreciate the artistry. So, for example, we understand that Guernica, Picasso's Guernica, is not realism. It is one take on what happened, and we celebrate it for its emotional power. With law, by contrast, we assume that there is a single perspective of facts, and that the applicable principles are accessible through rational debate based on language. However, law, like art, is a meaning-making activity that has material effects. But while artists are conscious of the constructed nature of their work, lawyers do not tend to be. Bringing the visual into conversation with law reminds us that the law also requires creativity and interpretation. Taking multiple perspectives into account will generate a richer and more nuanced account of legal principles that respond to a multidimensional world. Despite its assertion of a global reach, international law emerges as more multiple, fluid, and unstable, more bound up with plurality in the personal than the textual routines we're bound up usually suggest. So one important implication of personalizing international law means paying attention to the people whose voices are rarely heard in the design of the international system. This sculpture by the Congolese artist Freddy Simba at the African Museum in Niuru in Belgium captures this idea perfectly. It's made, I don't know if you can see it from the detail, from discarded metal, including cutlery, which you can see in the rib cages from the museum's renovation. The figures are set up against the wall of the museum as if they're being frisked. They're headless, according to the artist, to emphasize their anonymity. They represent for him the millions of people who are subject to humiliating treatment at national courts and denied refuge. This sculpture, it seems to me, challenges us to consider the human impact of international law, a challenge which is at the heart of this meeting.
Good evening, everyone. It's really wonderful to be here with you, and I'd like to start by expressing my sincere thanks to the American Society of International Law and to the International Legal Studies program at American University Washington College of Law for the invitation to be here today. It is a distinct honor to have the opportunity to comment on Judge Charlesworth's erudite Grotius Lecture, The Art of International Law, although I am a bit intimidated by the fact that I stand between you and the reception. So I will do my best to go as swiftly as possible. I would say that just getting to say Judge, oh, there you have the slides on the screen. Just getting to say Judge Charlesworth alone is very meaningful, since, as Dean Fairfax so rightly noted, she is only the 5th woman judge out of 110 total judges on the ICJ so far, and the first, as far as I am aware, who was openly espousing feminist approaches to international law before her election. This slide is a visual representation of all the work that still needs to be done for full inclusion of women in the field. Thanks to the hard work of feminist international lawyers like Hilary Charlesworth and others around the world, there is finally now an uptick in women's inclusion in the field, and that is great news, but the slide reminds us there is a very long way to go. So I want to start off by congratulating the 2022 Grotius Lecturer, Hilary Charlesworth, though she is not here in person today, and thanking her personally, and I'll see how many times I can say that word, thanking her personally and her whole generation of feminist international lawyers for working so hard for the inclusion of women in our field and for creating space for so many of us in the discipline. Turning to the substance of the lecture, as the former UN Special Rapporteur on Cultural Rights, I'm delighted that Judge Charlesworth has chosen to focus on the art of international law and to consider how the visual sphere affects the discipline. We are seeing ever greater international legal engagement in this area, and that is wonderful. Another example is the March 2020 symposium organized by ASIL Unbound on art, aesthetics, and international law. It was conceived by Marina Aksenova, and I was privileged to co-edit it with her, but she did the lion's share of the work. That symposium and this lecture today are evidence that art and international law are finally becoming acquainted. And I want to consider this intersection of international law and culture, specifically from a cultural rights perspective. So here I'm engaging a category that includes visual expression, but also goes beyond it to encompass other forms. The ASIL Unbound Symposium, like today's lecture, offered a critical opportunity for international legal scholars to engage with the value and power of certain aspects of culture. Hilary suggests that international lawyers have mainly focused on what art can do for international law. And I would say this is certainly true in some areas of international legal scholarship. However, I would add as a very friendly amendment that in the cultural rights field, perhaps a less well-known branch of international human rights law, we have also looked at what international law can and should do for art and for artists. And we've tried to consider both dimensions in a holistic and interconnected manner. International law protects artistic expression, even as artistic expression can help advance international law agendas. Cultural rights, including the right to take part in cultural life without discrimination and freedom of artistic expression, are prerequisites for communicating visually, as Hilary emphasizes is so important. These rights, though often forgotten, are a core part of the Universal Human Rights Framework, grounded in the Universal Declaration itself, and actually guaranteed by both of the international covenants on human rights. Cultural rights in and of themselves protect key aspects of the human experience, but they have also been increasingly recognized as important elements of accessing justice and responding to atrocities, and is fundamental to creating and maintaining peaceful and just societies. As I noted in a 2018 report to the Human Rights Council on socially engaged artistic initiatives, humanity dignifies, restores, and reimagines itself through creating, performing, preserving, and revising its cultural and artistic life. What could be more important than right now as we're grappling with the pandemic? Cultural practices and the arts are resources for marshaling attention to urgent concerns, such as the pandemic, as you see here in this mural. They are also critical for addressing conflicts, reconciling former enemies, memorializing the past, and imagining and giving substance to a more rights-friendly future. For further exploration of these themes, I highly recommend the work of Cynthia Cohen, including a co-authored piece of hers entitled Breathing Life into the Ashes. Despite these contributions that can be and are being made by artistic and cultural initiatives, international lawyers only rarely engage directly with cultural dimensions of their discipline, which makes Hilary's lecture even more extraordinary. Pablo de Greiff, the former UN Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-repetition, the UN always uses long titles, he has argued specifically that transitional justice has generally and systematically ignored claims of culture, and he has insisted on the importance of recognizing what he calls the unparalleled potential of cultural interventions and the critical roles they can and should play in transitional justice processes. Unfortunately, there are numerous obstacles to overcome in achieving such recognition of the potential of cultural initiatives, in the area of international justice and actually across the field of international law more broadly. One of the main stumbling blocks is that culture is often seen as less important, optional, a luxury item, even by some international lawyers and human rights defenders. For example, the International Criminal Court's decision to hear the Al-Mahdi case, which was the first ever standalone prosecution at the international level for the war crime of destroying cultural property, provoked what I found to be ill-informed criticism of the court by some, including some human rights advocates. These critics saw these crimes, that is the destruction of mausolea like this one, as being less important than other crimes that had taken place in the north of Mali. And there were many other crimes during the occupation in 2012. But I think they were overlooking the deep meaning that these acts of cultural heritage destruction had for the local population, as I found out firsthand when working with victims at the reparations phase of the case. These violent acts of cultural engineering had grave impacts on a range of their human rights, even if the offenses of destroying culturally significant buildings were not equivalent to direct attacks on human beings, and I would never make that claim. As the International Criminal Court itself described these crimes, they aimed at, quote, breaking the soul of the people of Timbuktu and were of significant gravity. This interpretation of the cultural dimensions of international crimes reinforces the case for culture being considered a critical element of discussions about international justice. A related problem in mainstreaming such perspectives is the view of arts and culture as separate from other aspects of experience, or as elite or cabined in cultural institutions. Overcoming such artificial boundaries can enrich our understanding and provide a more holistic view of international legal debates. As Marina Aksenova stressed during the editing of the ASIL Unbound Symposium, bringing art back in the sense of acknowledging its presence inherent in various activities and fields, including international law, is a way of reclaiming what has too often been overshadowed. Of course, the power of art is ambiguous, as Hilary herself notes, and there can also be many negative aspects and usages of images, as well as other forms of cultural expression in regard to human rights and law. Arts and images can be used to celebrate histories of human rights violations, to promote, as you see here, problematic narratives about current or past conflicts, or to incite discrimination and violence. And I think this is all the more reason to take arts and culture seriously as a sphere of analysis in international legal scholarship. In any case, surfacing the potential and the risks associated with the intersections of law and culture generally is a critically important task, and Judge Charlesworth's powerful lecture is a significant step in that direction, one that is to be warmly welcomed and that will hopefully be built on in future international legal scholarship. Her insights have actually sparked my thinking along numerous axes, and don't worry, I'm not going to take you along all of these axes at this point in the evening, but I will mention a few. One is to consider what a human rights respecting approach to visuality and international law could look like. As Sandra Ristovska writes in a recent book on visual imagery and human rights practice, incorporating the visual and imagining with and beyond it could strengthen the ability of human rights frameworks to respond to global injustice. And I think that is true for international law more generally. However, this also carries with it some methodological challenges and calls upon us to explore visual ethics and visual praxis in conscientious ways. And I cannot develop this fully here today, but we'll mention two elements. One is that we need to engage with the complexity of images, a problem magnified by contemporary technology. And ethical dilemmas associated with using images, I think, are increasing, involving security, privacy, and dignity, amongst other values. And secondly, I would mention that as visuals emerge so powerfully in some international legal debates, as we are seeing now with the illegal invasion of Ukraine, we also need to think about the effects of the images we do not see. And of course, there are all too many of those. I just want to mention a few more aspects of my thought about Hilary's lecture, but I'm actually going to skip that one in the interests of time. I think it's critical in listening to Hilary to underscore the creativity of image makers and the dangers and challenges that they so often face. This was a reality I confronted every day in my time in the UN's Cultural Rights Mandate. Around the world, artists, photographers, journalists, archivists are risking their lives, are being imprisoned, are facing human rights violations for making images and for preserving images. And here I come to a mural from Afghanistan's art lords. This is an organization headed by a person named Omaid Sharifi, and they painted murals against war and for human rights on the blast walls of Kabul, Afghanistan, that were needed to protect from Taliban suicide attacks, making those spaces and those structures fields of reflection and even paradoxically beautiful. Sadly, most, if not all, of their murals have now been painted over, and the art lords have all been forced into exile since the international community handed the country over to the Taliban. Yet the art lords and other displaced Afghan artists continue working with culture to sustain Afghans back home and in the diaspora and to support human rights in Afghanistan. And for another example, I think of the 76-year-old Russian artist Elena Osipova, who has been painting against the illegal invasion of Ukraine and has been arrested carrying her paintings in public, with those works sometimes being confiscated from her on the streets of St. Petersburg, as you see here. So I think we have to ask, how can our field do more to sustain and support cultural rights defenders, those who make and preserve images? That is something we have tried to do in the cultural rights field, and I hope that the reports produced by the UN's mandate in this area can be helpful tools, but so much more is needed. And as we embrace the power of visuality in international law more broadly, as Hilary challenges us to, we must also find more effective ways to use international law to defend those who make that process possible in the first place. I also started thinking after reading Hilary's lecture about how much it would change international legal debates if we were regularly confronted with images of those whose lives we are theorizing about, just as Niuru, in Hilary's words, intertwined legal arguments with imagery of its devastated landscape and thus advanced its case. I think of how images can complexify our arguments if we engage with them in a holistic manner. And here I turn, as an example, to how images might change the debate of the merits and lasting impacts of the Libya intervention, a debate which has resurfaced since Russia's invasion of Ukraine. I think it can help us to remember what is at stake by looking at images like the photograph you see here of the Libyan woman human rights defender and human rights lawyer, Selwa Bouguegas, who I met during an election observation mission to Tunisia in 2011. But this requires a complex reading of the image and its context. Selwa supported international intervention because she was from Benghazi and was a long-standing opponent of Muammar Gaddafi, who feared that his troops would decimate the population of her hometown. Whatever one's view of that intervention, her story unfortunately also clarifies the consequences of the lack of international follow-up after the same intervention. Given her work for women's rights and her attempts to foster genuine democracy in her country, she was assassinated by an Islamist militia in her home on June 25th of 2014. When I look at Selwa's image, I am reminded of just how much is at stake, so much more than our own personal commitment as international lawyers to our paradigms and positions. Images and stories can infuse our debates with complexity, with personality, with reality, and a greater sense of responsibility about the arguments that we make. So I hope we will see this lecture only as a beginning and take up Judge Charlesworth's challenge to imagine and construct a richer visual and even artistic practice for our discipline, which is essential, given, to paraphrase Shoshana Fellman, Sometimes precisely what needs to be heard in the field of international law cannot be articulated in legal language alone. Thank you very much.
Thank you very much. I want to thank Judge Charlesworth and Professor Bennoune for some fascinating and impactful remarks tonight. I also want to thank Dean Fairfax, Professor Padida Alaye, and WCL for its support of the Grotius Lecture. And as promised, there is a Grotius reception, which you can get through the registration lobby to the International Terrace West. And this is also sponsored by WCL. Again, really good to see all of you, and thank you to everyone